Welcome, everyone, to Resolute Live, the disability and employment law show. I have many different names for this show. Changes every week, but let's just go with it. I'm David Brannen, founder and lawyer at Resolute Employment and Disability Lawyers. Tonight's episode, we're going to be talking about how to appeal a denial of benefits in a smart way. We're going to be looking at two different parts. First, I'm going to talk to you a bit about CPP disability claims and reconsiderations and some things you want to keep in mind if you're going to do a successful CPP disability reconsideration. After that, I'm going to switch gears and we'll cover a topic that we get a lot of questions about: independent medical examinations. I'll talk about them mostly in the context of a long-term disability claim because that's where I see them the most. And I'll answer your questions. I'll go over some of the things just to keep in mind if you run into one of these exams. Now, as always, I will be doing question and answer throughout the evening. We'll be here for probably an hour and a half to 2 hours, however long we last. I don't want to bore people, so if you have questions, but I do have some stuff prepared. I'll go through these two topics. We'll go through the forum, answer some questions on there, the Disability Claim Canada Forum. I've also got a few cases we can look at, like we did the last time we were on here. We went through a CPP disability decision from the tribunal, and I kind of walked you through it and told you some things I think the person could do to improve their chances. And last week, the one we covered, I really think that person has a chance of success if they were to appeal to the next level. I also found an interesting long-term disability case that kind of crosses over with human rights. So we'll take a look at that as well. All right. Glad to have you all in here. Just go ahead and you can put your questions in the chat whenever you are ready to have me answer your questions. And with that, let's just dive right in. So the first topic tonight, we're going to talk about CPP disability reconsiderations. And I guess let's start with what is a reconsideration. This is the stage at a CPP disability claim when you have already put in your application and they have denied your application. So you put the application in, they've considered it, and they've sent you a letter saying that it's denied. Your next step then is to ask for a reconsideration and to file there's a process you go through, but to ask for the reconsideration. This is when it's not a brand new assessment. It's a second look at your case by someone new. They do assign it to a different person within Service Canada. So it's a different person than the person who decided your application. A new person will look at it, and they will either come to the same conclusion and deny your claim, or they have the power to overrule the first person and to award you your approval of disability benefits. Now, the person doing the review has all the same documents that the original person had. And generally, it is very unlikely that they will come to a different conclusion unless there is some new information provided that the original person did not have. Not always, but that is generally going to be the case. You will have to provide new information. So your job with a reconsideration is always to come up with a new angle, something new that you can give the reconsideration medical adjudicator, where they can kind of it gives them a way to overrule the first person, something different that the first person didn't have, to allow them to approve the case. Now, in an ideal world, when you get a denial letter, in the old days, when you got a denial letter, they would give a lot of detail in there on why your case was denied. However, that is not what happens now. From internal changes within Service Canada, they have really streamlined the process for doing these denials. I know that it's probably more efficient for them and avoids maybe mistakes and things. I don't know. But generally speaking, the letter you get denying your application will have no real details in it. It's really a pro forma letter that says the same thing for everyone, pretty much. There's a few reasons you can be denied, and they will just pick the one that applies to you, but it's the same general language that everyone will get who is denied for that reason. So it doesn't give you a lot to go on in order to craft the reconsideration that you want to do. So that is a weakness of this. I will say, from doing hundreds I don't know if I've done thousands of reconsiderations, maybe. I've definitely done hundreds. I haven't counted them up. I've done hundreds for sure. So in the hundreds that I have done, one of the biggest, there are many reasons why these get denied, but a reoccurring reason, especially in cases that are otherwise pretty good, would be a situation where the people lose because they misunderstand the minimum qualifying period. The minimum qualifying period is the period of time during which you must prove that your disability started in order to qualify for benefits. The way CPP disability works is that just because you've paid into the program, just because you've paid into CPP does not mean that you can qualify for CPP disability whenever you become disabled. No, your disability must arise when you had recent contributions into the plan. So this idea of a minimum qualifying period, it's the period of time that extends a bit beyond, it usually extends 1 to 2 years beyond when you stopped contributing to the plan, that covers a period during which you could still be approved for CPP disability, even though you weren't working and contributing in the year in question. So where I see people make mistakes is they will apply, they'll have been off work for several years and apply for CPP disability. And in doing so, they will talk a lot about what's going on in their life at the moment, the year they're applying, when in fact, they must prove that their disability started several years earlier and continued on to today. That is a big problem. That is something when we reviewed a case, I think maybe it wasn't last week, it was maybe the week before. I think I might have taken last week off. But one of the issues was that when we reviewed the case either last week or the week before, I can't quite remember, the person, that is what happened. And that person still has the ability to appeal their case. So I hope they do that. But they didn't have medical evidence from the time period where they had to prove the minimum that their disability started within the minimum qualifying period. In other words, it was pretty apparent from reading the decision that all the medical evidence they provided was after the minimum qualifying period. So for example, I think their minimum qualifying period was in 2021, but all the medical evidence they provided was 2023 and onward. That's why there was nothing there to prove what the disability was back in 2021. That's why a lot of people will lose these cases, just because for technical reasons, you are not lining up the proper medical evidence. In the Service Canada will not just take your word on it. They are very focused on medical records. And if you don't provide medical records during the years where you have to prove disability, you will almost certainly be denied. Almost certainly. Very, very difficult. In fact, probably impossible to be approved if you're not providing medical opinion or medical records directly on the years that you need to prove leading up to the minimum qualifying period ending. So for example, if your minimum qualifying period ends in 2021, December 2021, you must provide medical evidence either that was created leading up to and including 2021, or not as good but can work is to have doctors now talk about you in 2025, but the doctor would have to retrospectively give their opinions going back a couple of years until 2021. Okay. That's what I'm getting at there. Now, this is also a fault of doctors who are helping you fill out your application, or even if the doctor supports you in your claim, they won't understand this subtlety of CPP disability. In fact, even lawyers, people who otherwise you think would know, this is a subtle thing that is very unique to CPP disability. You wouldn't expect people to know about it who aren't working regularly with CPP disability claims. And so it is a trap that many people will fall into. So right from the start, you want to make sure that the medical evidence that you're providing with your reconsideration relates to the proper period of time. That's the first thing I look at, is what medical evidence did this person submit with their application? If I didn't do the application and I'm doing the reconsideration, I want to know what medical evidence was submitted And when is their MQP? That is the number one thing I want to know. When was their MQP? So what was the last date by which they have to prove their disability started? And did they provide any medical records during that period? If not, then the plan and for this appeal becomes pretty apparent in my mind of what we have to do. Now, when you do a reconsideration, you want to provide medical evidence, but you also want to provide a letter to Service Canada. I write these letters on behalf of clients, but if you're doing your own reconsideration, you will want to do a letter. Sometimes it's called a cover letter, but a letter that explains why you believe your claim should be approved. There's many ways to go about this. The way that a lawyer or a representative might write the letter is different than how you may want to write the letter if you're representing yourself. So just keep that in mind. There's no one right way to do this. Typically, though, with a letter like this, you will want to identify it as the written submissions in support of your reconsideration. You will want to correct any misunderstanding that you believe they have. It is helpful in the letter to summarize any of the new evidence that you have submitted and that you're attaching, and explain why that evidence would support you being approved for CPP disability. Then you just simply ask for the reconsideration based on the new information that you've submitted, and including the information you've given in this cover letter. I would say less is better. You don't want to write lots and lots of stuff, because there's a good chance that you can just create more problems if you are writing lots and lots of stuff. So yeah, you can create more problems for yourself if you're just writing lots and lots of stuff. If it's not focused, it creates more opportunities for you to create inconsistencies in the case. So for me personally, when I'm writing a reconsideration letter on behalf of a client, it's going to be 1 to 2 pages max. That will be single space pages, 1 to 2 pages maximum. I've had clients get mad at me because they think that's not enough. Why aren't I doing like a 10 to 20 page kind of reconsideration? And I would say, look, just because there's more there does not mean that it's better. At the phase of a reconsideration, you want to be very focused on the key issue, and a long written out report they won't read it, first of all. And you don't want to bury the good information within 20 pages. It's very possible, and in fact advisable, to just hit the high points on your reconsideration and to keep it to 1 to 2 pages. Okay, so let's go over some mistakes that people make. Some mistakes. So one thing is just resending the same information again. You don't have to resend the same information because it's already on the file. They will literally just hand it over. And I don't even, in the old days, they probably would have handed over a physical file. Now it's all on the computer. So they would just log in and see your information. You don't have to send the same stuff again. Now, that doesn't mean getting your doctor to write something new for you. That would not be the same if they write a new letter, unless they say the exact same things that they had said before. Generally, it is not helpful just to ask the doctor to write a new supportive letter, because they won't know really what to say. Like, they won't know what are the reasons it was denied. So getting the doctor to just blindly write a letter sometimes is better than nothing, but sometimes it really won't be that helpful if you're not giving the doctor any guidance on what the issues they should touch upon in the letter, that type of thing. The kind of things you want the doctor to highlight or to talk about in the letter will depend on your case. So for example, if this was a case where we had to prove that your disability started back in 2021, that's what I would focus on, is with the reconsideration, is I would have the doctor specifically talk to the point how long they have known you, that they have treated you long before 2021 and including up to present. And I would want them to talk about how your disability changed over time, if at all, and what your capacity was to work based on what they know now. Because the good thing is the doctor now has the benefit of hindsight. So based on what they know now and how they've seen your condition evolve, do they believe that you were capable of working on a regular basis back as of December 2021. And hopefully the doctor will say no if they weren't. The doctor says yes, they probably were, then, well, we're not going to win that reconsideration. But that would be an example of getting the doctor. If you don't say that to the doctor, they won't know that they should be talking about what was going on in 2021. They won't know that it's important for them to highlight how long they've known you, the relationship, how they've seen your condition evolve over time, whether they think you are a credible, believable person, that kind of thing. They will probably just write, this person cannot work. I don't believe they can work. And that type of report, if the key issue in your case is trying to prove disability back in 2021, if they're writing that report in 2025 or 2026, it's just not going to help at all. Okay. Now, I've already covered this, but the second mistake would be ignoring the minimum qualifying period or not understanding it and not building your case around it. So I won't go over that again because I've already touched on that. But suffice it to say that you have to get medical evidence that covers the period of your minimum qualifying period. And you can figure out your minimum qualifying period. There's formulas for how to do it. You can look it up online. You can read about it in my book on CPP disability. But generally, you need to figure out what that period is, and then you have to make sure you're getting medical records from that period of time present to now. Another mistake I see people make will be to write an overly emotional letter focusing on hardship and why it's unfair, why do other people get benefits, this type of thing. That is not helpful. Like it won't in fact, it can hurt. You risk offending the adjudicator if you are really trying to point out other groups of people who get all these benefits. Why aren't you getting the benefits? Like that kind of thing can just alienate the person who's deciding your case. So you don't want to do that. They will just discount everything you're saying if they think that you are just making emotional appeals or trying to come at it that way rather than focusing on the medical evidence. They have to prove your case based on medical evidence. It won't matter that you've always paid into this program, that you've never asked for anything before, that you really can't work. That type of letter will not be helpful. So you want to avoid it. Another mistake people will make is very much focusing on diagnosis and saying that you've now been diagnosed with this condition. This is, you focusing very much on the diagnosis rather than on the ability, how the diagnosis translates into loss of function. The problem is that people with the same diagnosis can have very different levels of disability, with some being able to continue working and others not being able to work. So the diagnosis alone is not enough. What CPP disability cares about is whether you have impairments that prevent you from working on a regular basis, or disability that prevents you from working on a regular basis. All right. So again, I've touched on this, but let's just go over it again. What does it mean to give new evidence? New evidence doesn't necessarily mean that it has to be recent. It just has to be something they didn't have before. In fact, often the best evidence that you can give, it would be like historical medical records. So this is not new in the sense that they were, these records could have been created 5 years ago, 10 years ago. They're just new to Service Canada because they didn't have them before. Often the best records would be those that were created for some other reason than your disability claim. So those records are often seen as more credible because they are not, there's no motive for you to, there's no motive there. So medical records that were created 10 years ago, they had nothing to do with this disability claim. If they're talking about your medical condition back then, they're more likely to be authentic and not biased. Whereas if the only evidence you have is evidence right now that was created after you started this disability claim, medical reports and this type of thing, courts can see them as less reliable because they were created while at a point when you had a motive to stretch the truth or to be untruthful, that you have a secondary motive here that you're trying to get a disability claim approved. Okay. We got a comment here. Put the evidence in the car. Thanks for continuing to share this great info. Yep, you're welcome. All right. Let's see what else we got here. So one of the other ways I approach reconsiderations is to keep in mind that what the limitations are here. So once your disability has been your disability claim's been denied by CPP, by Service Canada, you have 90 days to appeal. That's not a lot of time. What I recommend is that you immediately just write with a letter saying that please accept this letter as my written request for a reconsideration, and that I will be providing more documents and written submissions to follow. Okay. You don't have to wait and send everything in at the same time. We break it up into two things. So in order to do a reconsideration, you have to request it in writing before the 90-day deadline. I don't like to wait. I like to ask for that right away so that we are guaranteed not to miss the 90-day deadline. Missing the 90-day deadline is a big problem, and sometimes you can be forgiven for it, but many times you will not be forgiven, and you have to start all over, and you will now miss out on thousands of dollars in lost benefits because you have to start over, and your back pay can only go back a minimum of 12 months from the date of your application. So if you have to start over with a new application and it's been a year to get to this point, you've just lost out on a year of benefits that you would have otherwise gotten for back pay. So you really want to avoid the chance of missing the deadline. So what you should do is just immediately make a written request for the reconsideration. There's a reconsideration form that Service Canada has on there that you can get online. Fill that out, send it in, and just indicate that more information will follow. Please don't render a decision until you get my information that will follow. Then what you do is you get busy and try still within the 90 days, you try to get the new medical evidence that you're going to submit and get that ordered, received, and followed up to provide that to Service Canada before the 90-day deadline. That's basically what you should try to do. Sometimes it's impossible to do. And if it is, then you should still just do the reconsideration and move on. Know that in many cases, it's going to be very hard to get approved at this reconsideration stage. So it's more important to keep your case moving and to not miss the deadline to appeal. The best chance to be approved, in my opinion, is at the tribunal. You don't necessarily have to go to the tribunal hearing in order to be approved, but once you get to the tribunal phase, you put in a request for an appeal. A new person at Service Canada takes over your case. You then have a lot more time to get information into Service Canada. And more importantly, once you get to the tribunal phase, the tribunal will provide you right off the bat within the first 30 days of doing your appeal to the tribunal. You will get a complete copy of Service Canada's reconsideration claim file. So all the information that you provided to Service Canada, including your application, their internal notes, the medical records, etc., will all be provided to you once you get to the reconsideration phase. That is very valuable because now you can see more reasons for why they denied your claim, and it will give you better insight on how to get information and missing medical reports to address the concerns that they have indicated in the claim file that you've gotten. Now, it is possible to get an earlier version of this claim file, but what I have found is that by the time you request this claim file, let's say you come to me and say, David, I just got denied my application. I'd like you to do my reconsideration. Well, the ideal thing would be we would request a copy of your claim file from Service Canada so we get all the information. We no longer do that because by the time you request all that, you are very rarely going to get it within the 90 days based on when people are hiring us and in the such. So we're better off just doing the reconsideration based on whatever information we have and then just getting that file from Service Canada at the tribunal phase. And I have found that to be a more efficient way. Most people want to know, what is the fastest way in terms of months to get my claim approved? And my advice to them is, let's get the faster we can get through the reconsideration phase onto the tribunal phase when we get all the information quickly. That is the best thing to do. Otherwise, we could delay several months at the reconsideration phase getting all this information and be no more likely to be approved than had we just moved forward and got it to the tribunal phase faster. There's different opinions on that. I've gone back and forth over the years, but I'm at the point now where I really try to force cases as quickly as possible to the tribunal phase, because the cases, there's still an adjudicator on your case. Once they receive the new information, they can still approve your case before the tribunal. And I found it much more, we get the Service Canada claim file much more quickly at the tribunal, at the start of the tribunal phase, than we do asking for it during the reconsideration. So just take that as you will. All right. So let's take a look here. Let's go back. That's all I'm going to say on reconsiderations, unless people have specific questions about them. Certainly, it's a topic you can read about in my book. Do I have a copy of my book here? I don't think I do. Let me see if I can find it. Let me see. Where's my book? I'm literally just looking for a picture of it. Most people on here probably have seen my book, but you can also get a copy of my book on CPP disability just by clicking on the links down below, and it will take you. Yeah, I'm not seeing it. Usually I have it prepped and ready to go, but where is it? That's kind of annoying. Yeah, I don't have it handy. Oh, well, don't have it handy. Try one more thing. Yeah, anyway. Nope, don't have it. So the book is actually, I have it right here. Ugh. There it is. Hold this up to the camera. There you go. Beginner's Guide to CPP Disability. You can get a copy free from us. You can also buy it on Amazon. If you want a paperback, we will send you if you go to my website, just like I said, you can just go in the description. You can go to my link tree, and there's links there where you can download the book. All righty. Let's switch gears a little bit and go take a peek at the Disability Claim Forum and see if you guys can help me answer some questions. Let's share my screen. All right, so let's take a look at this. I'll make myself a little smaller here. There we go. So this is the Canadian Disability Claim Forum. This is a forum that I own and moderate. It's a great place to go to get your question answered by other people who are dealing with disability claims. Sometimes the best people for answers are not lawyers, but to just ask regular people who are dealing with the same problems as you. So let's look at this first one here. I don't even know what this is all about. Hotel and food on my taxes. What is this all about? I have a specialist appointment Tuesday. Ferry is free, but hotel and food will be expensive. It was mentioned I should write those expenses off. Has anyone ever tried that? Oh, yeah. So, yes, I think you can write these types of expenses off. Travel expenses for medical care are considered part of medical care, which can be written off. And Caro is pointing out that as long as it's reasonable that you have to travel for that, it's not going to be a problem. And this person says it's like a 6-hour trip to see the specialist. So, and they have to leave an island and all this kind of thing. So yeah, I would think that these are going to be, I would say that these are going to be able to be written off as part of your medical expenses for your taxes. But again, I'm not a tax expert at all. Definitely not a tax expert. All right. So where's another one here? Okay, this is one where there's some new, this looks like an old one. Okay. Right. So this is the original post here was about this phenomenon that will happen to you where if you're approved on long-term disability, the insurance company will require you to apply for CPP disability, and that will result in you getting less long-term disability benefits. Because under long-term disability and group insurance policies, they can deduct what they pay you by the same amount that you receive from CPP disability. So you can see how it's in their interest to have you apply for CPP disability because it will save them a lot of money, thousands of dollars a month, right? Usually your CPP disability is going to be $1,000 or more. So that's $1,000 less dollars a month that your insurance company is paying to you. So they have a very strong interest to have all their people who could qualify to be on CPP disability because it reduces the amount they have to pay out. So this person, Boomer 101, is saying, Manulife pulling the same thing with me. Go look at your original paperwork for LTD. Does not say you're required to apply for CPP. Just list how it could benefit you. What Manulife is doing is reducing their payment by how much your CPP. It's a scam. Billiard dollar profit company taking a handout from the taxpayer to put money in their pocket. I already emailed CTV on this, consulted a lawyer. Manulife plays this to save them money in their end of the day. They certainly do. I paid into this private insurance almost 30 years ago. So private insurance would be different. Private insurance would be different than group insurance. That's for sure. The scam needs to be exposed. I'll expose this. My MP didn't really have any idea how it worked. Okay. Now, Buckets is saying the actual LTD contract, not the policy information, will state that the insurer can estimate and deduct the CPP if you did not apply or claw back any CPP payments you don't actually get. Yeah, that is true for most group policies. It's extremely rare to have a policy that does not state this in the contract from your employer signed with the insurer. If your policy contract document doesn't state the above, it's really easy to tell Manulife to buzz off, and then there's nothing they can do to make you apply for CPP disability. Yeah. So this is 100% correct. I'm just going to add that, yeah. I'm going to add that this is for group LTD policies. This language is not as common with private individual. So Light Buckets says you always need to check your own policy or group benefits booklet. So most people have group LTD, and most group LTD has the clause that mentioned by buckets. There we go. So like it's not the first person. Whoops, that's wrong. That's not right. Let's try this again. The first person. Some people very fixate on it being a scam and things like that. Now, it's not always a scam because often it's written in the policy. I think that's what Buckets is trying to say, that like you can't just say that it's a scam. Like obviously they're doing it for money, but the policies that the policy that they signed, the contract that they made with the employer, because it's with the group policy, just in case people don't understand, group policies are between the insurance company and the employer or some other organization that represents a group of people. So the contract is with the employer and the insurer. They decide what they want to do. The insurer will give them a whole bunch of options, and if the employer was very adamant that they did not want CPP disability being deducted from the benefits, the insurer would say, "Oh, that's fine, but the premiums are going to be double." Right? So like that's literally what would happen. So the employer will say, "Well, I don't want the premiums to be double." So they'll say, "Well, then you should allow the CPP offset deduction. That way we can reduce the cost of it by half." I'm just saying, I don't know if it's exactly by half, but I'm just giving you an example. So the employer says, "Oh, of course, then that's what we'll do. We'll allow it to be deducted. That way the LTD will top them up and this kind of thing." That's how it works. So it's not a scam. Like everybody, when these are set up, that is what people choose. And in fact, if you give people the option, like especially if you're paying for these benefits out of your own, like your own paycheck, they're coming off your paycheck. Like, would you want to pay double the benefits for something that you might not ever use? If someone said to you, "Well, it would be half, but if you do get approved for LTD, it would be reduced by what your CPP is, but you'd get the same overall amount. It would just, some of it would come from CPP and some of it, everybody would say, "Oh yeah, that's fine." Like most people are interested in the here and now about what is it going to cost for these premiums. They're not thinking, "Oh, I'm going to be disabled and I'm going to need this." Like it's very few people that happens to, whereas everyone has to pay the premium. So just keep that in mind. All right, we got a little question here. Let's see what this says. So this is from Matthew. Hey, Matthew, how are you doing, man? During LTD psychological, is the medical examiner allowed to lie about things you said to your claims adjuster or health provider? My examiner said that someone in my file had said I was all ready to go back to work. However, I have never stated this to my claims adjuster, and my doctor has not changed his stance that my return to work date is unknown. I asked the medical examiner who had said this 3 or 4 times, and she refused to answer and eventually changed the subject. Is it possible to lie to someone about something like this? No, it wouldn't be ethical. Like police are allowed to lie to you. They actually are. Police are allowed to lie to you ethically, I guess, but not a doctor in an evaluation like this. So I would say that this doctor was either mistaken or maybe they were lying, or I shouldn't say they were lying. I mean, I don't know if they were lying, but they were either mistaken or assumed that people had said this. It might have just been based on their conversations with the insurance company representative. Maybe that person indicated that you were ready to go back. Someone in my file had said I was ready to go back to work. Yeah, the someone in your file could have been like the insurance people, right? So keep that part in mind. I don't know if the person that you were seeing for this IME was trying to imply that it was your own doctors and things like that, but it just could have been the insurance company people that were implying it. And you said, I have the interaction on a non-secret recording, if that helps. Okay. So I take that to mean you recorded it, but with the doctor's consent is what it sounds like, a non-secret recording. I doubt this doctor was lying, honestly, like knowingly. Maybe they were mistaken, but I don't see a doctor lying about something like this. It was probably more that maybe they got you mixed up with another case, or the insurance company people are indicating that they feel like you're ready to go back. It's more likely what's going on here. All right. Well, why don't we move on to talk a bit more about independent medical examinations. And Matthew's saying, not a doctor, a psychologist. Yeah, but they have the same ethical obligations. A psychologist has the same ethical obligations as a doctor. Any regulated health profession would, so they would not be allowed to lie to a patient. Now, they could say things that are not correct, but they probably are not doing it. They're not knowingly doing it. It's a mistake, is probably what's going on. That would be my guess. All right, let's talk a bit about that. Leads us right into independent medical examinations. So independent medical examinations are they're often called IME for short, independent medical examination, IME. You'll often hear it worded that way. Now, they're not truly independent at all, usually because they are paid for either by the insurance company or by the disability claimant themselves. Somebody's paying for this assessment, and that would make it not truly independent, because there is somebody paying, and once you get financial incentives in there, it's hard to be truly independent. Now, usually this is going to be done by an assessment done by a psychologist, as Matthew was just talking about. So it can be done by a psychologist. It can be done by a doctor, a physician, different types of specialists. It can be done by a physiotherapist. Like, there's many people that can do independent medical examinations. The idea behind an independent medical examination, it's a one-time examination where the purpose of it is to give a medical legal opinion about your ability. Like, the purpose is to give an opinion that goes towards either a injury claim or answers questions about a disability claim. So that's what makes it unique. It's not treatment. Independent medical examinations are something very distinct from getting treatment or a consultation for treatment. They are not that. They are specifically done for the person doing the assessment to be able to answer questions related to basically issues around a disability claim or injury claim. Something to keep in mind, and I bring this up with we get a lot of questions, and I have to reiterate this to people, that going to independent medical examinations are not optional. Attendance is typically required as a condition of the long-term disability insurance policy. And it can be worded in different ways. It might not say the word independent medical examination in the wording of the policy, but there's different ways it can be worded to make this type of assessment mandatory. And failure to attend would amount to a breach of your policy, which in and of itself is reason for them to deny your claim. Even if you're otherwise meeting all the requirements for disability, if you breach any part of the policy, that's grounds for them to deny benefits. So that is the reason that I tell people you must attend these appointments. Another thing that annoys people, and I agree, it annoys me too, is that the insurance company, whoever's paying for the independent medical assessment, let's just put it that way, whoever's paying for the independent medical assessment gets to choose who does the assessment. If you're paying for it, you obviously pick who you want. If the insurance company's paying for it, they get to pick who they want. You may not like the person they pick. You might think they're not the right type of medical specialist. You may Google their name and see all kinds of terrible things written about them online. Like, there's a million reasons why you may not agree, but it doesn't matter. Except for extreme situations, which are quite rare, you would be required to attend the medical assessment with the person chosen by the insurance company. There are some exceptions because sometimes the insurance companies want you to travel by plane, by out of province, these kinds of things. Now they would have to pay for everything related to your trip. And so there are corner cases where maybe it is unreasonable to make you travel too far or these types of things. But my advice to people is don't look for ways to get out of doing the assessment. Look for ways to make it work, because the sooner you get these assessments, the sooner your case can move along. You don't want to get into a long, protracted fight over who the medical assessment is going to be, where is it going to be, and all these types of things, unless it's absolutely necessary, because it will delay your case. It will delay you getting opinions, and it can look bad on you later on if a judge is reviewing your case to see that you were obstructionist with trying to allow the insurance company to get this done. Again, this assessment is allowed for under the policy. They get to choose who they want. Your best approach is to go to the assessment, try to figure out ways to make it work, go to the assessment in good faith, and worst case scenario, it goes just as you would expect, that they write a report that's not favorable to you and the insurance company cuts off your benefits. That's the worst case scenario. And actually, no, that's the expected scenario. The worst case scenario is that you refuse to go, and the doctor, therefore you're denied, not based on your medical condition, but you're denied based on a breach of the policy. So now you are in a really rough spot, because now the only question on whether you are entitled to benefits is, did they request you to attend an assessment? Yes. Was it a reasonable request? Probably yes. Did you attend? No. Then there you go. You're not entitled to benefits. Like, you don't want your disability claim to be reduced to that, and it can be. Okay. So this is why you want to attend these. The best case scenario is you go, and much to your surprise, the independent medical assessment will come back in your favor. I've been involved in enough cases. I've been involved probably in more cases than anybody on this live stream right now. And I can tell you that they do go in your favor from time to time, sometimes very unexpectedly. I distinctly remember the very first time ever that one of these went in my favor. And I was very shocked, because the doctor in question was very well known for always supporting the insurance company. And I was shocked. I can tell you the other lawyer was shocked who represented the insurance company. I can tell you the insurance company was, everybody was shocked that the report came back in our favor, but it did. And it ended up, my client's claim got approved eventually after a little bit more fighting, but it's pretty hard for them to deny a claim once the doctor they sent you to is supporting you. So you have nothing to lose by going to these appointments, and only things to gain. So what I say, when you have something to lose, it's that your claim will get denied for non-attendance, which makes it very difficult to get the claim approved going forward. You basically, to undo that, if you come to me and say, David, I want you to appeal this, I'll say, look, there's no appeal. Like, you have to crawl back to the insurance and get them to book another assessment. Maybe you got to pay the fee. Sometimes people bail on these things at the last minute, even worse, because now there's like a cancellation fee. So maybe you got to pay the cancel. Like, there's all kinds of terrible ways this can go if you bail out on these things. So yeah, you may have to pay the cancellation fee, get this thing rebooked, and then have the insurance company will obviously pay for the new one, but they may require you to pay the cancellation fee, which is reasonable for you to do if you bailed on the last minute. And once this assessment is done, now if it comes back and they deny your claim based on medical evidence, now we have something to appeal. We can't appeal the fact that you didn't attend an assessment. That's very, very difficult to win that type of appeal. Not a good fight to be having. All right. Here's a good question. At what point during the claim does the insurance ask for IME assessment? Is there any time or any rhyme or reason? There is rhyme or reason, and the most common times you will see this done would be in the months leading up to when you get to the change of definition. So that is the most common time you will see this done. especially if there's not good medical evidence to deny your claim based on what's existing, they will get an independent medical assessment to give them grounds to deny your claim at the change of definition. Another time, in cases that are very, what I would call high, like it's a high benefit claim, like the benefit amount is very high, so it's an expensive claim. You will see these done much earlier. They can be done right off the bat sometimes, early in a claim. So you do your application. They may want you to get an independent medical done as part of the assessment early on, especially if they don't think your doctor is really doing everything. They will get an independent medical assessment early sometimes in order to help try to dictate your treatment. And a good reason for them to get these early is the independent medical examination will give a bunch of recommendations. Then if they get that done early in your case, so let's say they do that within the first year, let's just say you don't follow the recommendations, your doctor doesn't, that's now grounds for them to deny your claim, because they can say, well, if you'd have done these recommendations, according to this doctor, you were going to have been better in 6 to 8 months. So you didn't do the recommendations, you're not better. You failed to mitigate your damages, so we're going to deny your claim, and they would have a good shot at that. So that's another reason they will get these done early, is if they feel like your doctor is not managing things well, they will. And I'm not saying that they're setting you up for fail. Like they're legitimately getting advice that they think will help your situation. Let's just be the most charitable here. And if you and your doctor choose not to follow that advice, it is at your own peril. The best thing to do is follow the advice and then show that it didn't help, that it didn't work. Then it takes all the wind out of these independent medical examinations. So that is what you'd want to make sure happens. If you ever have these done, you must follow the recommendations, or at least have your doctor address the recommendations and say why or why not that they're not being followed. All right. So independent medicals, they are very important. Obviously, these are done by doctors who are very good at doing these types of assessments. They get training on how to do it. Some doctors make millions of dollars a year doing these types of assessments. So it's big money, and they're very good at being thorough. Like, think about it. Their only job is to assess you and give very well-written answers to the insurance company's questions about why or why not, like what your condition, what your impairments are, what treatment you should get, whether you should be able to work or not. They're getting paid a lot of money, and they get very good at writing these reports in a way that is favorable to insurance companies. So they can be very hard to overcome sometimes. Often the only way to overcome them is to get your own expert report to go against it, or to have your doctor review it and give rebuttals to why this information is not correct. Remember that you do have a secret advantage in that the independent medical expert only sees you at one point in time, like for a few hours. They often won't have the complete picture of everything. If you're lucky, the insurance company will either intentionally or unintentionally not give them all the information. So they have a limited view of your whole situation. They may be missing critical information. Your doctor has known you. On the other hand, compare that with your doctor who's known you for a longer period of time and can often be more credible because they know you better. They've seen you over time. They can better assess your credibility, etc. Now, that's just a play that kind of goes back and forth. And it won't always be in your favor. Like, your family doctor won't always get the full benefit of the doubt, but they will in many cases. So what is it? If you haven't been to one of these, I'm sure people on the call, I know Matthew's been to one. Many people on the line here probably have been to one of these medical examinations before, but they're not great. You have to go to a doctor's office usually, and they usually take anywhere from 45 minutes to 2 hours. The doctors handle them differently, but often there's a period of time where there's an interview that can involve you filling out forms, the doctor interviewing you about your symptoms and then such. There'll be a period where they do some assessment, physical testing with you, and there will be a period where they just observe you. So you have to understand with these independent medicals that the assessment starts Sometimes as soon as you leave your house that day. Independent medicals are a prime time for surveillance to be done. So often it's good for the insurance company to get somebody secretly recording you from when you leave your house to when you get there and to when you leave and what you do after you leave. That way they can compare that to what you say to the doctor and see if there's any inconsistencies in what you're saying. Like if they're videotaping you the whole way there, do they have you like walking out of the car and then start limping? Like that would be the obvious, that would be the worst case scenario for a plaintiff. If you were faking and you would get caught because they're videoing you. The other thing is if you describe if you don't, they can compare it because like you will have said, sometimes they will ask you about what you did this morning, how were you, like, so they'll find things that can kind of contradict. Another thing is if you say that after the assessment you were totally tired out, you can't do anything, that's part of the assessment had to end early because you're too exhausted, and then they have you on video going to the mall or going and doing other things. Like that's what they're hoping to find, some kind of really inconsistent thing like that. So just keep in mind that the evaluation starts as soon as you get up that day, potentially, because you could be videotaped on the way there. You're being observed when you are there. So they're like, when you're sitting in the waiting room, they're seeing how long can you sit in the chair. When you're filling out paperwork, they're measuring how long can you sit in a chair doing work, right? So then when you say, oh, I can only sit for 20 minutes without getting up. Well, they've just observed you for an hour and a half filling out paperwork without getting up, sitting in their chairs like that. This is the kind of inconsistencies they're looking for. They're using the whole attendance of your time there as part of the assessment, including when you're in the waiting room. So just keep that in mind. The best way you can approach these, though, is to come in with an open mind and to a good attitude. These doctors do these assessments all the time. If you come in with a combative attitude or trying to be snarky with them, that will not help your situation. If you are coming in with a positive attitude, in good faith, they will pick up on that. They're more likely to view you more positively if you are treating them better and more respectful. Sometimes impressions matter. A lot of things are subjective. If you are fitting into a lot of stereotypes that they commonly see, they're more likely to make poor assumptions about you or to give you less charitable views on things. If you are positive, they feel like you're doing this in good faith, they're more likely to have a positive view of you and give you the benefit of the doubt, to be more charitable when trying to assess whether you are giving a full effort or being truthful with them. It does matter. They are human, so do keep that in mind. Now, what happens when these are done? So there often can be like a back and forth of people wanting the doctors to guarantee to give them a copy of the report and all these things. This has been fought out, and the outcome is that these are not standard medical reports. They're the property of the insurance company. The doctor does not have to give it to you directly. They give the report to the insurance company, and then you get it from the insurance company. You cannot demand that the doctor give it to you directly. These independent medical examinations have been distinguished from other types of medical treatment of which you would be entitled to get it directly from the doctor. Okay. But these have a carve out. They're different. So don't try to play those games with the doctor. You won't get anywhere on it. Just you get the report directly from the insurance company, not from the doctor. Just keep that in mind. Now, if the independent medical comes back and it's not in your favor, like that's kind of what you're expecting anyway, you still want to review it with your doctor. Your doctor can give a rebuttal or can send you to a specialist who might be able to give a different opinion. It's important to point out any factual mistakes, but you have to be careful because some things there might be factual mistakes and others are just matters of opinion. So you can't just force them to change things where they give an opinion that you disagree with. Okay. So just keep that in mind. I do see people wanting to try to get these reports changed, amended, thrown out, because again, if it's over matters of opinion, they're allowed to have opinions. There's nothing you can do about it, right? If your birthday is misstated, then that is something you want to get them to correct. If the dates of your employment are misstated, then get those corrected. If their view on whether you are disabled or not, that is not something that can be disputed. It's their opinion, so they're allowed to keep that in the report. All right, so just to wrap this one up, I don't want to go on too long about it. Independent medicals, keep in mind that the best thing you can do is just go to them with an open mind, make it happen, get them done and out of the way. It really doesn't serve you well to fight them, to try not to attend. You really just dig holes for yourself in terms of if God forbid, like you get denied based on failure to attend, or worse yet, you bail at the last minute and now there's a cancellation fee and the insurer won't send you to another one until you pay the cancellation fee. So you can really put yourself in a mess that can all be avoided just by attending these as quickly as possible and get them out of the way. All right, Matthew, you've been to one of these recently. If medical examinations is done virtually, whose fault is it if the software the examiner chooses to use is not working correctly? Example, they cannot see you through your webcam, which can be proven to be working, and there is a loud echo that can be proven to be because of the lack of IT knowledge of the examiner and possibly their hardware. Yeah, look, there's not much you can do there. Again, you only have to go into this in good faith, but it's, again, you want to try to avoid these problems if possible. Like if there is an issue with cameras, usually that is going to be on the end of the person who's being recorded. So typically it is not going to be their end. I know you're saying it can be proven. I don't know. I'm not going to judge whether you can prove that or not, but sometimes these things are not easy to prove. But if you're saying you could prove it, then you can prove it. But again, the question would be like, were you keeping the camera off? Were they? These are just problems with technology. So in a situation like this, you might have to redo the assessment. But that's unfortunate. Yeah. These things come up. I mean, I do meetings with clients via Zoom, and we have things that goes off the rails every now and then. Nothing you can do about it. But a lot of if it's a no webcam issue, that is usually at the side of the person it's usually not the person on the other end. It's usually your end where that would be the problem. But I'm not saying that's what happened in your case, but just be aware that it's often hard to prove that. Should nurse practitioner provide IME current medical tests and records? Yes. So oftentimes when you're being prepared for an IME, the IME person will want updated records from your nurse practitioner, your family doctor. Yes, you should agree to have those records sent over to the independent medical. You want to go at it from the point of view to give them all the information necessary to be helpful, to do it in good faith. And so that would include allowing them to get the records. You don't want to withhold this information because, again, it creates a negative inference about you. You are withholding their ability to give a good opinion and report, and it can be held against you. So this person follows up to say, employer self-administers LTD and is paying for IME. Will I receive a copy of the IME? Generally, yes, you can get a copy from the employer who is self-administering. Now, the employer self-administers, but I expect that they have a third-party administrator who administers the LTD. They don't do it personally, like right through the HR department kind of thing. So whoever is administering the LTD on behalf of the employer will be the people that you talk to about getting a copy of the IME. Generally, yes, you will get a copy of it at some point, especially if they're going to deny your claim based on the IME. You would get a copy of it. It doesn't really serve them well to withhold the IME from you and then deny you based on it. They're better off allowing you to see it and then have your doctor comment on it. Often, like I said, there's recommendations in the IME for treatment and such. So it will really hurt the insurance company to withhold an IME. There was a case in Nova Scotia where there was an IME that had medical recommendations, and the insurer withheld the IME from the claimant until almost to the point of trial. And that did result in a very big punitive damage award against the insurance company for failure to give out the IME earlier, especially because it was supportive of the plaintiff's claim, and also it had medical advice in there that could have helped them as well. So they got a big punitive award. Now, I think that punitive award was later knocked down, but the court was very angry about that. Often when you don't see the IME right away, it can be because it came back in your favor and they're kind of scrambling around what they're going to do. Sometimes they will write back to the doctor to see if they give them more information, to see if it changes their opinion. And but it's very hard for an insurance company to just bury an IME, like not give it out at all if it's helpful to you. They have a good faith obligation to they have a good faith obligation to you. Now, in a self-insured situation, the employer still has a good faith obligation with you to give you information like this. So at some point, yes, you can get a copy of that, but maybe not right away. All right. Good questions, folks. Good questions. All right, that's enough talking about that. Let's go take a look at, we did a thing last week that I thought was kind of interesting. Maybe we'll do it again. I brought up this point. Let me share my screen here again. I think it was Menia who's on the call here on the show here this week. I asked I went through all these decisions. These are all decisions from the Social Security Tribunal for like the most recent ones. So the most recent decision is what's that? August 30th. And I said, I went through all the decisions. These are all CPP disability decisions. They all were a loss. Every one of them was a loss for the month of August, which I thought was that was pretty brutal. Yeah, they all lost. Even in July, I think July were all losers too, if I'm not mistaken. But what I like to do is just pick a random case here. Let's pick a random case. Let's go find one way back here. Let's find a random case and see. Let's pick one where the person lost and see if we can figure out ways that they could have won that case. I like these more recent ones because in theory, these people still can appeal. If you lose, well, depending on the level, but if these were cases at the Social Security Tribunal General Division, the people still have a chance to, win the case. But let's just take a random one. I want to get one that I haven't seen. So this one here, let's see, YC versus Minister of Employment and Social Development. All right. Oh, this was an in-person hearing. Wow. You don't see those very often. Let's see. Was this approved? Oh, appeals allowed. We don't want that. We want ones where they're denied. Let's try this one. DA. Teleconference. Appeal dismissed. Okay. Here's one that's dismissed. So let's go see if we can figure this one out. So let's look at this one. This is a decision from July, August, September, October. So this person has until today, well, maybe a little bit later, but they have to get their appeal in basically by like today or tomorrow if this person was going to appeal. So this was a hearing done by teleconference. Okay, so this is not a video. Usually they're by Zoom. So this person did their tribunal by telephone, which I've done many of those. They go fine. And the tribunal member was Don Kershaw. So the appeal is dismissed, isn't entitled to payment of the disability pension before April 2023. This decision explains why I'm dismissing the appeal. Okay. Okay. So this, all right. So this is a case where, this is interesting. So this is a case where someone got approved, but they only got back pay. So when you get approved, there will be a retroactive payment that you get. So this person was approved as of March, and the back pay only went back to April the year before. So which is like 11 months. That's normal. It's 12 if you include the current month or whatever. But anyway, whatever. It's 11 months back. This person appealed thinking they should have got benefits back further. I can already see where this is going to go. Yeah, so they're saying this is cases, yeah, I've done these cases before. So in order to get, there is a way to get more than the 11 months, but you have to be able to prove that you had an incapacity to apply earlier than you did. That's what they're talking about here. It says here, however, if the incapacity rule applies, a person application is deemed to have made earlier than it in fact was. I did one of these. The biggest case I ever won for CP in terms of money wise was one of these incapacity cases. I represented someone who lost at the tribunal, the general division, and she wanted me to help her appeal to the appeals division, and I agreed to do so. And before it got to a final decision, there was a settlement conference, and CPP actually agreed to approve the claim. I was shocked. Like, it was the first time that I've been involved in winning a case on this argument of incapacity. Now, I had a lawyer contact me a month or two ago looking for a consultation with them and their client. They brought me in as kind of an expert because their client wanted to make this incapacity argument, and I told them basically there's no chance. So this person did not win. So let's take a look at it. So for the appellant to succeed, he has to prove that the incapacity rule applies to him. That is correct. This means he has to prove that he was incapable of forming or expressing an intention to make an application before March 2024. Incapable of forming or expressing the intention to make an application. Okay, do you see how hard that is? That is such a difficult thing to prove. This doesn't say anything about that you didn't know about it. So it has nothing to do with you didn't know there was a need to appeal. You didn't know there was a such thing as CPP disability. It's like you were incapable of forming or expressing an intention to make an application. So it's more like you almost have to think of situations where you're like in a coma. That would be one way you could prove this. The case that we were successful with, the person in question was homeless and on the street with untreated mental illness. So they were often delusional, off medication, and on drugs all the time. So they accepted that this person was in such bad condition that they were not capable of forming or expressing an intention to apply because they were in a constant state of either being on drugs or delusional, having different types of mental illness but that is not going to apply to most people. So they go on to say here, the legal test is very strict. Okay. It isn't the same as the test for disability. A person with disability is still able to form and express an intention to apply. Under the test for incapacity, it doesn't matter. Yeah, I've just said this. It doesn't matter whether the appellant knew that it existed, knew that they had to apply, thought about applying, could make or prepare or comprehend the application himself. Okay. So it doesn't matter that you couldn't do it yourself. All you have to be able to do is have the capacity to form the intention to apply. So the fact that you couldn't do the application yourself is not enough. So in this case, the appellant was represented by his wife, and she wanted to testify. Okay, so he did. All right. Reasons for my decision. This judge found the incapacity rule didn't apply. What the appellant says about why he didn't apply. Appellant was diagnosed with Parkinson's. Okay, so this is a serious condition that could lead to an incapacity. Appellant says he said he calls it PD because he can't accept it. I will do the same with the decision. When I asked the appellant why he didn't apply for CPP disability pension sooner, he said his disability shocked him. He was in denial. Okay, right off the bat, that is not a reason, unfortunately. He says that he was incapacitated from the time he got his diagnosis. He said he was been incapacitated ever since. So just because you might be physically incapacitated, the fact that he's able to carry on a conversation with this judge shows that he likely had the capacity to form the intention to apply. So he was isolating himself after the diagnosis. He had a hard time accepting it. He was depressed in a dark place, etc. These are all not reasons that you would be able to meet that test, because even in that state, you could still form the intention to apply. Like, your brain is still working and capable of forming an intention to apply. So you can see they must have asked him a lot about his activities, because sometimes when you see people's activities, you can then extrapolate, okay, based on these, are they doing intentional activities, like where they're forming intentions to do things, and would those translate to being able to also form an intention to apply for CPP disability? That is kind of what they're looking at here. Yeah. Right. So even as early as 2023, he held a job for only 3 months. He wasn't incapacitated from a physical perspective. His doctor said his speech was clear and fluent. He was able to write. Yeah. So unfortunately, like, I would agree with, just based on this information, that this person would not meet that test. Similar to the lawyer and their client that I met with a couple months back, a month or two back, where I basically told them, look, there's no chance. Like, you obviously can have an intention to apply. You just didn't do so for various reasons. But unfortunately, like, it has to be a situation where you're in a coma, or you have such a severe mental illness and you are so detached from society that it's just not, it would be the same as you almost being in a coma, where you're just completely out of your mind and not living in reality. All right. Now, here's another case I was talking about. This is one I noticed. So I saw this. I was looking for recent cases dealing with insurance companies, and this one came up that I thought was interesting. So in this case, this individual, Allen v. Sun Life, this person made a human rights complaint against Sun Life, which is interesting. So this was someone on LTD, and they made a claim against their LTD insurance company, a human rights complaint, which seems to me to be very odd. This isn't somewhere where you would think that you would ever be successful with a human rights complaint. And this did not go well for the person. Now, they were alleging discrimination and disability as the grounds for discrimination. Specifically, they said during a mediation. So it looks like this person attended a mediation with, they attended a mediation, and the mediation did not go well. And said they responded against her by making a comment suggesting the disability she was experiencing was not legitimate, and by refusing to allow rescheduling of the mediation. So these are, like, I don't want to, again, I don't want to belittle the person who made this. Like, they obviously felt very strongly about this, but generally, like, these types of comments in the context of a disability claim are not going to be considered discrimination. It's not discrimination to say, we don't believe that you have a disability. Again, because this is a unique context with dealing with an insurance company whose job it is to assess whether or not you have a disability. The other thing would be, mediation is something that is mediation is something that has to be, it's not mandatory typically. It's something that is both parties have to agree to. So the fact they don't want to do a mediation would not be discrimination. It's just a choice you have in the context usually of litigation. But again, I don't know all the facts here. I just found it was an interesting case because it was a long-term disability claimant who wanted to try to make a disability, who wanted to bring a discrimination claim against the insurance company. It says, in this case, the applicant commits civil action against the insurance company claiming entitlement to LTD. That's totally normal. An attempt to resolve the dispute, the parties attended mediation. In the application, the applicant alleges that during the mediation, they said, "Nice try," followed by the applicant's indication that she intended to leave the room to vomit because of her disability. The respondent allegedly refused to allow rescheduling of the mediation, instead continued to make harassing comments. I have no doubt that they were probably unnecessarily mean to this person. No doubt about it. It can be very unpleasant. People can say very poor things in these contexts because you got to look at it from the insurance companies and their lawyers' point of view. If they really think you're a faker, like, they will show disdain towards you in this type of thing. If you know you're not a faker, that can be extremely insulting. And I've been on the other end of that, where it is very insulting when I believe my client is telling the truth and they're being treated like a liar by the other side. Yeah, so they're saying that this dispute is not in the context of a service provider, and just be the nature of them, because this is they're saying that the insurance company is not acting in the context of being a service provider, because you can make discrimination complaints against service providers. I would agree with the decision here that in this context, they're not a service provider. They are a party to a lawsuit, and they're acting in the context of the lawsuit, the litigation. It is an adversarial relationship, so you would expect there to be adversarial comments and animosity, if bordering on unprofessional at some point. Interesting. I found this interesting, though. Furthermore, the application may be outside the tribunal's jurisdiction because of the doctrine of absolute privilege. The tribunal has held that comments made or actions taken by parties in the context of complicated judicial or quasi-judicial proceedings cannot be the subject of human rights complaints. So in other words, like, things said in the context of a mediation or in context of settlement cannot be used to form the basis of a human rights complaint, which is interesting. I had not seen that before, but it does make sense. All right. All right, we have another question here. So let's, here, let me just clear up my screen here a little bit. Let me clear it up here. We got that. And I had another question come through. It says here, can I bring registered clinical counselor to MIT? Okay, can I bring a registered clinical counselor to IME for mental health support? Generally, that is something you'd have to clear through the independent medical assessor, but generally they don't want you bringing people to the assessment because it affects the assessment. So that is just something to keep in mind. But that is something you could talk to the IME about, on what type of medical support you would need. Remember, like, you are seeing a health professional. So whoever is doing the medical assessment is a health professional and should be able to deal with you in a sensitive way if you have reasonable requests and things like that. But you're not going to be able to bring in a counselor with you, but that is something you could ask them about. Sometimes they'll agree to have like an observer person in the room with you, but that's usually someone on their own staff if you just want an observer person. But that is something you could bring up with them. If it was medically required, or if your doctor had said that this is something that's recommended, but again, I would try to avoid these types of things if possible. I don't know your situation. I would try not to complicate it, but if you feel this is absolutely necessary, then it is something you could explore, but it is generally not going to be something that they will agree to. Okay. Well, we're coming up on an hour and a half, which is a good time. Let me know if there's any other questions. I'm going to call this meeting to an end. I'll be back next week. This week, I'm going to be working hard. It's a short week here because we just had Thanksgiving. I'm traveling this week to go speak at Dalhousie University to the School of Occupational Therapy. I got invited to come in and talk for the afternoon on a kind of a topic important to them, more around the laws that relate to the professionalism and duties and these types of things. So I'll be speaking with them later this week. Apart from that, though, it's good hanging out here tonight. I thank you all for the great questions. I will see you back here next week. I wish you all a good time until then. Take care.